Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات قبل أن تختار المحامي الذي سيدافع عن قضيته. دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. أنتم أوقاتا مستمعين في كل مكان، أهلا بكم في حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز على الهواء مباشرة. نستقبل اتصالاتكم ومشاركاتكم في البرنامج على الأرقام 313-769-6666 519-256-1023 ودائما عن طريق الواتساب برسائل نصية أو صوتية، والرقم هو 313-327-7074. مكاتب المحامية جومانا كيروز تقدم لكم استشارات مجانية في الاختصاصات التي يتعامل معها، وهي قضايا الإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، قضايا الهجرة والتجنس، قضايا الإفلاس والضمان الاجتماعي، وقوانين العائلة. 248-557-3645. أهلا ومرحبا بكم. وأيضا نذكركم مستمعين بحلقات برنامج يور رايت موجودة على اليوتيوب. نحمل هذه الحلقات يوميا، بإمكانكم العودة إليها والاستماع للمعلومات المقدمة فيها. كل ما عليكم هو زيارة قناة جومانا كيروز على اليوتيوب. تحياتنا لكم. جومانا، مساء الخير.
مساء الخير رامي، يعطيك ألف عافية. كيفك اليوم؟
الله يعافيك، الحمد لله. نسأل عنك، إن شاء الله بخير.
كتر خير الله. مساء الخير لكل المستمعين. عم بتبلش الشمس تطلع، هيئته نهار كمان جميل. ومساء الخير لضيفنا اليوم. كان مفروض يكون ضيفنا الخميس الماضي، عم يظهر معنا مرة بالشهر المحامي جاي ياسو. كان عنا خلل تقني الخميس الماضي، فنحن اليوم مستقبلينه. Attorney Jay Yasso, it is a pleasure to have you with us again today. We apologize about what happened last Thursday. How are you doing?
Thank you, Joumana. It's my pleasure to be with you and your audience.
Thank you very much, Jay. Happy to have you. We are now having you, and you are accommodating us once a month. We very much appreciate it. And we've moved our meetings to Thursday because there is a lot of demand for talking about car accidents and the new auto law every Wednesday. So thank you for working with us. Attorney Jay Yasso is a specialist in medical malpractice, meaning errors, negligence that's the result of somebody in the medical field, the pharmaceutical field, the hospital field, the nursing field. The term medical is an umbrella for nursing, pharmaceutical, hospital. Anybody who is associated with the medical field, that comes under the umbrella of medical malpractice. So an example of medical malpractice can be, God forbid, a pharmacy error. An example of medical malpractice can be, a doctor error. An example of medical malpractice can be a nursing error. It can be a hospital staff error, and so forth and so on. They all come under the umbrella of medical malpractice. In fact, one of the things we were going to talk about last Thursday is also when you have an FDA-approved medication, or in that case, it was a gel, this is medical malpractice, although we are precluded in Michigan from bringing such lawsuits because of a defective medication, so to speak. But you have had a number of these cases on a certain gel applied outside the body, and we'll talk about it in a minute. And you are co-counseling on these cases with another law firm. I believe you said out of New Jersey. Is that correct?
Yeah, it's all rather new. It's actually a product liability case because you're dealing with a product that was, we believe, contaminated, and it resulted in an injury to patients who were using it. This particular gel is only used with what they call it with a bone stimulator. It's a machine to help heal your bone when you have a fracture of the bone. So they use the machine and then use the gel. Well, the gel was contaminated, and so the problem, one of the issues we have, and we'll talk about that in a little while, is that in Michigan, because
May
of
I
our
interrupt for a minute? You
yes,
called it a product liability. This is a medication. Do we also call it a product in the context of product liability, even if it's a medication?
yeah, absolutely, because you have to kind of look see where the product went bad. It wasn't the doctor did anything wrong. The doctor is just dispensing it. It's the plant where this product was being manufactured. And we know that because they sent out a recall notice after patients were using it saying, hey, by the way, these batches of gel that's been handed out, and your client might be one of them, have microbacterial contaminants. I mean, they're actually telling you this, and they want to make sure that you don't use it and return it. Well, some patients are using it, like my client, and has sustained significant injury to her lower leg.
Right. You said that she was having a surgery maybe, and this gel is applied for faster healing, but
Correct.
it was contaminated with bacteria, and so the bacteria went to her bone and her femur, which is,
Correct.
I believe you said, the largest bone in our leg, became necrotic, meaning that the tissue died. And so she had her femur removed, her largest muscle, largest bone.
Largest bone, correct. Yes.
Between the hip and the knee. That's the largest bone in our legs. That's the femur. She had to have it removed. So can she have use of that leg or no? When you don't have the femur, do they put a stent in there, or do they put another piece of metal in there?
So if you can envision the leg from the hip to the knee area, so at the base of it all is a bone, and around the bone is wrapped with muscle and nerves and tendons all around it. It's the bone that's been damaged. The infection went all the way down to the bone, and it's a fancy term called osteomyelitis. And so she developed this condition. They ended up going in there and removing the bone, so it's left only the flesh around it. Well, you can't walk around with just the flesh. You need the bone. So what they ended up doing is inserting a rod from that area that they removed. So they may have removed about 8 or 10 inches of her femur. And by the way, the femur is not just the biggest bone in your leg, but I believe, and I'm not a doctor, but I believe it's the biggest bone in your body.
Okay. What is the name of that gel by any?
Yeah, so the company is called Bioventus.
Right.
And yeah, Bioventus, and they're out of North Carolina.
Mm-hmm.
So
Now,
again, recall notices have gone out.
Sure, and the way they know, the way the company that manufactured that product knows where to send the notice to, we get them every once in a while in our mail, is because once you buy, your name goes into a data entry, and that's, I believe, by federal law, so that if they need to reach you to warn you about a recall, whether it is a car or whether it is a medication or whether it is any other product, they know where to mail you the information.
Correct. Absolutely.
Okay.
Correct.
Did you say, and again, we don't have product liability in Michigan. It's been precluded in Michigan. For how long, Jay? Since tort reform?
So I want to be accurate on this. We have some product liability, but back in 1993, I think 1994 timeframe, just like they did with medical malpractice, there was a statute that was passed. Well, they passed a statute affecting product liability. And then basically what it says was, and does still today, 26, 27 years later, is that any product, and a product could be drugs, or it could be something that the FDA can approve. So, the FDA approves drugs, they approve food, okay? If any of that is FDA approved and it goes into the stream of commerce where consumers are using it, consuming it, etc., and they get injured, under Michigan law, you can't sue the manufacturer, okay? You can't sue them unless you show gross negligence. And that's a very high bar to overcome by anybody. So they basically essentially have eliminated those types of cases. So yes, drugs, medical devices, hips, knees, things of that nature. Some of them, most of them, I think are FDA approved. So in Michigan, we can't sue, but there are a lot of states that do allow those lawsuits, and we align ourselves with those law firms from other states to bring these lawsuits on behalf of our clients.
Thank you very much. أول شغلة عم نحكي عنها هي ما كانت أول شغلة بدنا نحكي عنها but so be it. هي إنه ابتداء من سنة 1993-94 بولاية ميشيغان طلعوا قانون Michigan Compiled Law بتقول إنه أي product يعني FDA approved. FDA يعني Food Drug Administration. يعني food products, they have to be FDA approved. Drugs have to be FDA approved. Medical devices have to be FDA approved. القانون اللي طلع بسنة 1993-94 بيقول إنه بولاية ميشيغان ما بنقدر نقدم دعوة ضد الصانع هذا الفود ولا هذا الفيتامين ولا هذا الدراج ولا هذا الميديكال ديفايس إلا إذا قدرنا أثبتنا gross negligence مش ordinary negligence. عادة نستعمل كمحاميين personal injury إن كان بسبب خطأ طبي أو إن كان بسبب حادث سيارة أو إن كان بسبب انزلاق. المطلوب منا قانونيا نثبت أنه الطرف الآخر أهمل مش إهمال فظيع. يعني المطلوب منا نفرجي negligence مش gross negligence. gross negligence تقريبا شبه مستحيل يقدر الإنسان يفرجيها. لهذا السبب في ولاية ميشيغان في قانون بيسمح لنا أنه نقدم هؤلاء الشكوات، وإنما المطلوب منا شيء كتير صعب نقدر نثبته. لازم نقدر نثبت انه المانيفاكتشر تبع الفيتامين او تبع الدراج او تبع الميديكيشن او تبع الميديكال ديفايس او تبع الجيل ان ذس كين مش بس كان اهمل، بس اهماله كان كتير فظيع. شو بنعمل؟ بنتعاون مع مكاتب محاميين قايمين بهدول القضايا بغير ولايات، لانه بغير ولايات اجمالا نيوجيرسي وبعض الولايات الاخرى القانون هناك بيرحم أكتر من هون، لأنه القانون هناك ما بيفرض على اللي بده يقدم شكوى أنه يثبت إهمال فظيع، بس فقط يثبت إهمال ordinary negligence not gross negligence. فإن the case اللي كنا عم نحكي عن الجل هؤلاء عنده جاي 2 cases من قبل شخصين هون في ولاية ميشيغان. بدل ما يقوم دعوة هون ليقدر يحاول يثبت إهمال فظيع اللي هو كمان مرة كتير صعب نقدر نثبته، عم يتعامل مع مكتب محاماة خارج الولاية بولاية أخرى where all they have to show is regular negligence not ordinary negligence. كتير من الأوقات وقت بيكون في ريكول، يعني بيكون في طلب بينبهوا الكونسيومر اللي اشترى إن كان فيتامين إن كان ميديكال ديفايس إن كان ميديسن، بيبعثوا لهم رسائل بالبريد، لأنه القانون الفيدرالي بيجبر إنه كل ما بنشتري دواء، كل ما بنشتري فيتامين، كل ما بنشتري anything regulated by the FDA approved إنه يكون اسمنا وعنواننا in data entry، لحتى إذا لا سمح الله صار في ريكول على البرودكت بيعرفوا لوين يبلغونا، بيعرفوا لوين يبعتوا لنا رسالة تبليغ. الجل اللي عم نحكي عنه هو جل للأشخاص اللي بيعملوا عمليات، ومفروض ينحط على الجلد من برا، ومفروض تسرع the healing process، يعني الإنسان بصح بطريقة أسرع. للأسف هذا الجل كنا عم نحكي عنه by way of example كمثل، طلع فيه بكتيريا، يعني طلع فيه contamination، يعني مطرح من صنع المانيفاكتشر اللي صنعه I believe he said North Carolina, correct Jay?
Correct.
North
That's
Carolina.
correct. Yes.
المانيفاكتشر بنورث كارولاينا لسبب أو لآخر صنع he put on the market bacterially infected contaminants. اللي صار للسيدة اللي وحدة من اثنين اللي عم بيمثلهم المحامي جاي ياسو إنه حطت الجل بناء على تعاليم الدكتور تبعها أو الجراح تبعها. نوتس إنه الجراح هون مش عامل غلط، الجراح عم يتبع تعاليم محطوطة على الجل. هو ما صنع الجل، هو recommended the gel. الغلطة مش غلطة الجراح، الغلطة غلطة صانع هذا الجل اللي هو المانيفاكتشر out of North Carolina. وقت اللي حطته على الجرح المفتوح تبعها فات للعظم وفات لأكبر عظمة بجسد بإجر الشخص، ويمكن بيقول جاي يمكن بجسد الشخص. إذا في حكي ما بيتسمع بيقدر يأكد لنا إذا الفيمر هي أكبر بون بجسم الإنسان بتصور it is. نزلت البكتيريا، نزلت للعظم، نزلت للفيمر اللي هي العظمة بين الحوض وبين الركبة يعني دني، وصار في نيكروسيس يعني التشو قاعد. اضطروا يعملوا لها عملية ويشيلوا لها الفيمر. طبعا الله حطت لنا فيمر بإجرنا لأنه بحاجة نستعملها لنقدر نوقف على إجرينا. الإصابة تبعها كتير هائلة، اضطروا يشيلوا لها الفيمر ويحطوا لها راد، يحطوا لها حديد. هذا من الكيسز اللي بيسموه product liability، يعني هو مش ضد دكتور أو مستشفى أو ممرض أو فرماشية، هو ضد manufacturer، هو ضد صانع ل product that was FDA approved. Actually, we wanted Attorney Jay Yasso to start with, we're getting a lot of calls from people and we encourage them to continue calls because they do not know. So until they talk to an expert, they should not draw conclusion on their own. So let me start by saying that. Having said that, we're getting a lot of calls where, something bad happened, but the outcome today is okay. Something bad happened, but the outcome is okay. So the question is, does this person have a case? And let me qualify it. Does this person have a case that will net to a recovery or no? So Jay, go ahead, please.
Sure. So I guess the best way to answer it is just to tell your audience about what we as lawyers have to prove in court in order to prevail, in order to win. So to answer your question is, one of the things that we have to prove is damages. And that's a fancy legal term to indicate injury. What is my client's injury? The other two things we have to show is that there was some breach of the standard of care by the doctor, or whatever field of medicine he or she may be in. And then we have to show causation, standard of care that caused damages. So what you're asking about, what your question talks about is that last part. We get clients who call and they say, doctor, performed 3 surgeries on my knee, and I went through 3 rehabilitations and 3 recoveries and a lot of anesthesia, and I was sidelined for months, and et cetera, et cetera. And then I will ask that client, how are you doing today? And the client will say, I'm doing great. I'm back to normal. I'm working. I'm playing tennis, blah, blah, blah. As soon as they say that to me, I say to the client, I'm sorry. There's really nothing at all that I can do to help you. Not because they really don't have a case, but because they really don't have any damages that will justify a case. And we talked a long time ago, and on a few occasions. I'm sorry.
May I interrupt for a minute? So yes. You're saying not necessarily that they don't have a case, but that they don't have a case that you and other medical malpractice lawyers are willing to take. You're not necessarily saying that no negligence happened. You're not necessarily saying that the second and third surgery were unnecessary had the first surgery been done correctly. You're not at all necessarily saying that. You're saying even if there was negligence, even if it's 100% certain that there was negligence, then the reason you're not taking the case, is it because the damages are not permanent. Is that what we're looking for? Permanent damages?
Yeah. So you said it accurately. Yeah. I tell my clients, medicine is not a perfect science. Doctors are learning new things every day and new techniques and new medication. Everything changes, so it's not a perfect science. But we expect that doctors will do a reasonable job, not high level 10 out of 10 job. We're talking about reasonable job. And a lot of times with any surgery, for instance, if we're talking about surgery, there's the risk that you might need a revision procedure, another procedure to make the first procedure go well. That's not malpractice. You might develop an infection. That's a risk in the procedure. That's not malpractice. And the second infection might require a second surgery and a third surgery. So even though you're getting those surgeries, and even assume, based on your question, that let's say the doctor committed negligence on all three first surgeries, but got it right on the fourth surgery. If she got it right and you're fine, you have no damages. What starts to happen is, and I hate talking money to my clients, but I have to because we invest a ton of money into these cases, and we're not shy. We do it all the time. But what happens is when our clients get better.
When we say money, we say as low as $15,000, $20,000 and as high as $100,000, because the experts you deal with are very, very, very expensive. They're anywhere from $500 to $1,500 an hour. The doctors.
Correct. 100%. And so what happens is the math really doesn't work very well. We spend a lot of money. Our clients get better after the third or fourth surgery, and they have little damages. Then the other side, the insurance companies and their lawyers aren't interested in paying somebody who has recovered, or they might give you a few $1,000s. Well, what is that going to do? Because that's going to pay for the cost that's been incurred by my law firm. And then the client or the patient who's been injured walks away with nothing in their pocket after 2 or 3 years of hard litigation. So I tell that to the clients a lot of times. I don't want you to think you don't have a case. You might have a case, but economically, it really doesn't make any sense. And the only thing that we can sue for is money damages. The only thing. I can't make your knee better. I can sue for money damages. And if you get better, they don't pay you a lot of damages.
And a lot of clients tell you, I am not here for money. I want justice.
Okay.
What do they mean by justice? Because you cannot turn back the wheels of time, that we know. You cannot reconstruct the standard of care. What's done is done. What do they mean when they say justice sometimes?
It's a great question, and I see it a lot, and I hear a lot about it. I really think that they want to make sure that really this doesn't happen again. Whatever happened to their loved one by this doctor or hospital or nurse doesn't happen to anybody else. And you're right. A lot of them come in and say, I'm not in it for the money. It's not
and
about
we believe them.
100%. We do. But what you have to do is then educate them about the process. And the process requires us investing money in order to get you money. So it is about money. And so I understand that, they don't, but I tell my clients, there are other avenues that you can take to try to get justice. It's not really maybe through me as a civil lawyer who sues for money damages to compensate his clients, but maybe you can go to the state of Michigan site. And there is an agency that oversees the doctors and the medical professions. And you can file a civil complaint online that will get investigated. That's another way of getting heard, getting heard, which is not about money. There it's just about getting somebody to investigate to see if what they did was negligent or something. But it's not about money,
So I'm saying a lot of things. Number one, you're saying even when there is negligence, if today the injuries are no longer there and the person has made a nice recovery, despite all the negligence in the world, and assuming that for a minute, the cost that you have to invest as a law firm versus the financial reward that you will get as a law firm it's not going to add up because the cost will be a lot more than the recovery. So let's say you spend $25,000 on a case, and that's really a very low number, and you recover $25,000 or even $50,000. The client is going to walk with nothing because you have to take back. The law allows you to take back your cost. So now the 50,000 has become 25,000, and you take your 1/3. So what does that leave the client with? And I'm throwing numbers. So the damages today, not a month ago, not 6 months ago, not all the suffering, not all the unnecessary surgeries. And we know it sounds very cold, but it's a I don't know what the right word is, but it's really a financial decision. One of the first things I learned from attorney Harry Philo, he taught me to say, because when I started in my career, I did medical malpractice. And he said, when you talk to a client and we are turning her or his case down, be careful not to say you don't have a case when there is negligence or when we think there is negligence. Say, I'm not saying you don't have a case. I'm saying you don't have a case that our firm is willing to take because we believe the cost of litigating this case will exceed the likely recovery on this case. And as we were preparing last Thursday, we were talking about what's called a Pyrrhic victory. We talked about that when people get traffic tickets that they don't deserve and they don't want to pay. They don't want just to have the points go away and pay the fine and call it a day. No, they want to go prove that they want justice. And it's true. If for a minute, you got a ticket you do not deserve. Well, it's how is it fair that you have to now pay a fine? How is that fair? What have you done? Well, it costs money. You know, principles cost money, like we said before a couple of times on the radio, and here too. I say to them, you want to hire a lawyer who will go to trial on your traffic ticket, because a city attorney does not have the authority to dismiss your ticket. It only has the authority to take it down from what it is to something less than. But if you want to prove your innocence, you have to have a trial and you have to appear in front of that judge. And that judge, in all likelihood, is not in your favor because he or she is used to having that same officer all the time. The likelihood of winning is very slim. You'll be paying about $1,500 to a lawyer to defend you in the traffic ticket, where your likelihood of winning is very, very slim. And even if you win, let's assume you won. Let's assume you got your day in court and the judge believed you and you are innocent. Your ticket got dismissed. Well, that's a Pyrrhic victory. It's a victory in theory, but it leaves you unsatisfied. Most of the people, it leaves them unsatisfied. Some people, they don't care. They will spend the money to prove a point. But most people, it's a bittersweet victory. Yes, in theory, on paper, you won. You got your ticket dismissed, but you paid $1,500. You took time away from your life to go try this case. And, you know, you are short $1,500 or more. And the same here. When they say they want justice, again, sometimes the sad reality is that as a firm, you have to be careful. It's a business. Your law firm is a business too, in the sense that what you spend has to be less in payroll, in expenses, in cost, has to be less than what you make. Otherwise, you will become bankrupt. And that's another thing Harry Philo used to say. What is the important thing for a law firm? It is a business too, and we need to stay. He used to use very strong terms. This man was a legal giant, bless his soul. He used to say, you need to stay out of bankruptcy. You need to stay out of bankruptcy. The other thing he used to say is the purpose of tort liability, which is what you do, which is what I do, is the ideal purpose is the ideal, he used to say, is the prevention of injury. So we don't want tort products. We want to lobby. We want to systems that are so stringent and strong that before you put a car out, before you put a gel out, you did everything to protect the consumer. So he would say the true purpose of tort liability is injury prevention. But, he goes, but when that fails, then money damages. And I know I've done a lot of talking, but I feel very passionate about that. All you can do is to keep your firm out of bankruptcy. Actually, your firm is a very, very successful older than 75 years. Everybody knows the very prestigious law firm of Summers and Schwartz, but it's on the mind of every lawyer, every law firm, every small lawyer, a small law firm, medium-sized law firm, is that in the cases you keep, as much as you want sometimes to get justice by putting a defendant, an at-fault doctor, and so forth through the legal system to give them a slap on the hand, if that's going to cost you more than you're likely to recover because the injuries today are not big or resolved, then you have to very sadly say, I'm sorry, I'm not telling you don't have a case, but it's a case I cannot take.
And there are a lot of those cases. You know, the other thing, Joumana, as you were speaking, I was thinking of was that, you know, I mean, in addition to just getting monetary damages for our clients to try to compensate them for their injuries or for their losses, the other thing, as you just touched upon, is that, you know, filing these lawsuits really, really does prevent the next case from happening, that is the next injury from occurring, because a lot of patients and consumers probably don't know what goes on behind the scenes at these major hospitals and medical centers, but there are all kinds of boards and committees that are formed so that when something goes wrong, there's one called a peer review committee where they basically go ahead.
That's every doctor's nightmare, is get called by a hospital for a peer review because a bad outcome happened on one of her or his patients.
Yeah. So the hospitals have their own policing system in place so that they can, roundtable the issue, find out what happened, not necessarily to try to settle with us plaintiffs' lawyers, but just internally to work on it so that, again, this doesn't happen again. So, patients ought to know that when they go to lawyers and have their lawsuits heard in court, it really does send a strong message to, again, these big insurance companies and the hospitals and these big corporations that, they've got to change their ways so as to prevent these injuries from occurring again.
Attorney Jay Yasso, I believe that you as an attorney are not entitled to obtain a copy of the findings from a peer review, correct?
Yeah, that's correct. It's all very confidential. It's private. And there's, we try to see if maybe we can get an incident report or some kind of a summary, but there's statute.
It's not part of the patient's file that you order, right?
No, it's not part of the patient's file. Correct.
Okay, so you really don't know what goes behind closed doors when a board of doctors bring in the doctor in trouble, so to speak, what they go through and what conclusions they draw and all that. And sometimes they will suspend the doctor. They will revoke the doctor's privileges because this doctor is if they find that this doctor is posing a risk in the future to that hospital, no hospital on their right mind want that.
Yeah. So this revocation of license and suspensions and all that is sort of what those clients that come to us and say that they want justice, that's sort of justice. That's what you're getting right now. You're reprimanding the doctor for their mistakes, and it's not about money, but it's, again, sending a message that what he or she did was, below the standard of care.
Let's take a quick break, Attorney Jay Yasso, and let's return with the mother-baby scenario that walked into our office not too long ago. Very sad story.
مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات. قبل أن تختار المحامي الذي سيدافع عن قضيتك، دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. مكتب المحامية جومانا كيروز يعلن عن استقبال الموكلين والمراجعين في العنوان الجديد 24370 نورث ويسترن هايواي ساوثفيلد على مسافة قريبة من موقع المكتب القديم. مكتب المحامية جومانا كيروز يتعامل مع كافة قضاياكم المتعلقة بالإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، بالإضافة إلى قضاء الهجرة والتجنس، الإفلاس، الضمان الاجتماعي وقوانين العائلة، والاستشارات مجانية. 248-557-3645. Your Rights مع المحامية جومانا كيروز. عودة إلى برنامج Your Rights. أرقام الهواتف في الاستوديو 313-769-6666 519-256-1023. دائما على الواتساب 313-327-7074. جومانا نرجع لك.
شكرا. بالشهر بنستضيف المحامي جاي ياسو اللي عنده خبرة هائلة في موضوع أو في قانون الأخطاء الطبية، وهو من مكتب محاماة عريق جدا في ميشيغان، عمره أكثر من 75 سنة. هو مكتب سامرز أند شوارتز. المحامي جاي ياسو ما بيشتغل بمكتبنا بس بيتعاون مع مكتبنا، بيشاركنا من خبرته. رجعنا هلأ مرة بالشهر on a Thursday. attorney واللي بيحب يتصل أو بده يبعث لنا سؤال تحت الهواء no problem. هيدي الحلقة تعاد أو تنزل على يوتيوب قريبا ليلي بيحب يتسمع عليها من جديد على the Joumana Kayrouz يوتيوب channel. Joumana Kayrouz يوتيوب channel. إذا بينعمل سبسكرايب، إذا الشخص اللي عم بيتسمع حابب يعمل سبسكرايب، بيتبلغ كل مرة وقت اللي مننزل حلقة. وبالمعدل مننزل بالمعدل مننزل 5 حلقات بالأسبوع، كل يوم عن موضوع مختلف جدا. ما نعطي كتير تفاصيل دقيقة، بدنا نتكلم عن سيناريو حزين جدا 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 لسيدة تفضلت لعنا من الجالية، عندها إصابات بسبب ولادة، وخلاصة الأمر خسرت كل الريبرودكتيف أورجنز تبعها، مع أنه هي كتير صغيرة بالعمر. رح نقول عمرها 26 سنة بس هو عمرها حتى أقل من هيك. بعد ما ولدت الطفل تبعها صار مشاكل، وبسبب هذه المشاكل اضطروا يشيلوا لها كل الفيميل ريبرودكتيف أورجن، يعني الرحم، I forgot what the two on the two sides are. شيلوا لها كل reproductive organs تبعها. وطبعا هي كانت نيتها تجيب أكتر أطفال، وهي جاية على أساس أنه شاكة أنه يمكن في خطأ طبي بخصوصها هي. الطفل عمره بعد الشهور اكتشفنا in the meanwhile أنه الخطأ الطبي مش بس تجاه الأم، هو كمان تجاه الطفل. attorney Jay Yasso, let's say that the young lady who came to our office is 26 years old. We want to change it just a tad. She came because she thought that maybe what she suffered personally after giving birth to her first and only child, she may have suffered negligence. You tell us about this in detail and tell us how you discovered what brought her here, concerns about her, because she lost all of her reproductive organs as a result. She can no longer have babies ever. Tell us what you also discovered about the baby.
Yeah, it was really interesting. And through the assistance of your office, and I'm sorry to say, I wish I spoke Arabic, but I had to use one of your assistants to help translate. But just a wonderful young couple who came in, and
Iraqi clients are not going to be happy. You being Iraqi of origin, they're not going to be happy. You don't.
I'm sorry.
Do you speak Chaldean?
I do speak Chaldean.
Oh, okay. Well, then why are you discriminating against the Arabic language?
I'm not. The reality is that back home, we spoke Chaldean at home, and then in the public they spoke Arabic. Well, I got lifted out of the 2nd grade and brought to this country, so I really didn't learn a lot of Arabic. My older brothers and sisters all speak Arabic, but I was young, and so I didn't really. But I understand quite a bit. I just can't put it together.
No problem.
But again, really nice couple, and they really came to you and me because mom, I believe she might be even younger than 26. I want to say about 23, had just gone through a situation where she delivered her baby, a full-term baby, and And, she came to me because she said after she delivered the baby, she was bleeding a lot. And so they kept her in the hospital, and she was bleeding a lot. And then they kept her overnight. And then the next day they discovered, we're not sure yet, but we're still trying to figure this out. But what they call retained products of conception. That's really the afterbirth, the placenta and everything else that comes in after the birth. They believe that some of that material was still left inside of her. Not sure yet. So, so within a couple of days, because she was bleeding so much, they ended up removing all of her female parts. That would include her uterus, her fallopian tubes.
Yes, that's the term, yes.
And the ovaries. Okay. And if you don't have ovaries, which produces the female hormone, I think it's the estrogen, then you have to be on pills for hormones for the rest of your life. But besides that, obviously she can't have any more children. Okay. And now she's young. So as I'm talking to her, I turned my attention and I said, "How is your baby doing?" And she said, I'm not sure. And I said, "Well, what do you mean you're not sure?" Well, he was taken within hours away from me after he was delivered and taken to Children's Hospital for 25 days. Remember, she didn't come to talk to me about her child. She came to talk to me about herself and the complications she was having by having a complete hysterectomy. And so, long story short, I got more information about her son, who was pale upon birth, was not breathing, not sucking. And she told me something that was very, very important. And that is that they ended up cooling his head for 2 days at Children's Hospital. So what they do is they put this thing over your head, which shoots off some coolness in order to, and the reason why they do it is because they believe that the brain did not receive enough oxygen before birth. And this cooling of the head causes the blood to rush to the brain, hopefully to get the brain to work like it's supposed to. A lot of times we find that these children have brain damage. Okay. So I bring that whole thing up because, our clients really don't know a lot of times where the malpractice lies and what's going on. So in her case, we're going to be, and we are investigating both cases on her behalf. Why at her age is she having a complete hysterectomy? Why weren't they monitoring her condition, not just during birth, but after birth? Okay. And then, of course, we're going to look into the baby's case as well as to whether or not the baby's just too young. Baby's only like 2 months old. So we have to wait until this child grows up a little bit more to see if he will be, reaching any of the milestones that children reach as they grow up, sitting, standing, crawling, all that stuff.
You did say that as she was giving you a history about the child, it appeared that, he had very low APGAR scores. These are the scores that a nurse will write down about the color of the baby, the reaction of the baby, and so forth and so on. And he had very low APGAR scores. And also you did say that, did you see some of the fetal strips while she was pregnant, while she was delivering, that showed the decelerations and accelerations we're talking about? Or
no, we have not gotten the records, but even someone who doesn't speak English as well as they did, they were really astute about what was around them during the labor and delivery room. First of all, Dad, for cultural reasons, decided to stay outside the room, so it was just Mom by herself. And Mom says she says the baby's heart rate would go up really high for like 5 or 6 minutes. And you can see that, by the way, by the strips, the fetal monitor strips, which are right next to you and are attached to your belly, so they can pick up the baby's heart rate and all that. But then she said the baby's heart rate would stabilize, and then the baby's heart rate went south. It went low, which indicates that the baby's not getting enough oxygen for about 22 minutes.
Oh, my goodness.
And nobody's watching. And so that's why you say, where is the negligence? So negligence is somebody needs to be monitoring this stuff, because what they're supposed to do is that as soon as they detect, I'm sorry, go ahead.
I'm sorry to interrupt. Yes, go ahead.
The thing that they're supposed to do and what they're trained to do is, if they think the baby is in distress while inside of mom. You rush the baby and mom to have a C-section, an emergency C-section. You get that baby out. You don't wait because baby's losing oxygen. Okay, and they're all trained to do that, and they didn't do it.
Um, this is such a sad story. I wish this is a case we never had. Um, this is also, we're not going to say which hospital, but this is one of the well-known hospitals in the Tri-County area, right?
It's a major medical center in the area, correct.
So is there anything we can tell people, anything they can walk away with? I mean, what are you supposed to be a doctor now and know when you're suffering a D-cell and late D-cell, you're suffering an XL, and I don't understand. What can one do? Like, one feels utterly helpless in situations like that when they are in the hands of doctors. What do they know? They're very vulnerable. They've not gone to medical school. Is there anything? Oh, you did tell me also that the doctor who delivered her was not her OB, regular doctor, right?
Yeah, so a lot of times you have these OBs working out of the same group. And for instance, if you go into labor on any given night or whatever, one of the guys of the group would be on call. And so you may or may not get the person
Nothing wrong with that.
Yes, that's what happens. I think that may have happened. So the person that really knew most about her condition, that saw her throughout the prenatal course, a female physician, was not there when she delivered or when they got into complications.
And we are not saying that is wrong or that is negligent. I mean, a lot of OB groups are like that. What they normally do, because I've gone through it with my daughter, is as you get closer to your due date, they start introducing you at your next visit. They have it with another doctor and then another doctor, so that on the day you are due or when you are in delivery, as you're going through labor, whichever doctor happens to be on call, it will be the one to give birth. And that's somebody you've had at least one interaction with. We're not saying any of this to say that there was anything negligent. And it doesn't matter, even if the doctor who knew most about her, unless she was a high-risk pregnancy, and she was not, unless there was anything special about her, any doctor and any nurse should be alert to, what's going on with the fetal strips, the accelerations and the decelerations and so forth.
Right.
So you will be looking at the OB, you will be looking at the OB nurses, correct? You'll be looking at everybody here to see who, and probably more than one person was wrong, maybe more than one person.
Yeah. So what happens in a lot of these major medical centers is that you have, like what I say, are a lot of cooks in the kitchen. You'll have the labor and delivery nurses, and then you'll have the OBs coming in and out. Then you'll have the residents coming in and out because they're being trained, and anesthesiologists will come in and so forth. So you really have to look and see whose responsibility is what to bring alarming signals from the fetal monitor strips to the attention of the attending physician. And there's this whole hierarchy of who you're supposed to talk to and so forth. So there's that end of it. And then, of course, after the baby's delivered, now you got the neonatal area. Okay, did something go wrong there that caused the baby to have the injury? Probably not. I think it was during the course of labor.
After birth.
After birth.
The 25 days spent at Children's.
I'm sorry, I did not hear your question.
During the 25 days spent by the infant at Children's Hospital. You have to look into that too.
You look at it, but we believe more likely than not that the damage was already done before that child was transferred to Children's Hospital. Okay, so because the hypoxic, the lack of oxygen to the brain, we believe, we don't have the records yet, but we believe based upon mom's testimony that it happened while the baby was inside of mom.
So we have 5 minutes remaining. We started almost this show by saying that sometimes you turn down cases, not because there was no negligence, but because the damages are not permanent and are not big. This is an example of one, because the cost might exceed the likelihood of recovery or the amount of recovery. This example of baby and mom, she's coming to you already, even forget the baby. Mom already has lost all of her reproductive organs. That's a permanent injury. So that's one. And two, this is the likelihood of recovery if there is negligence. If negligence is proven at the end of the day as to mom or as to child or as to both, the likelihood of recovery by your firm will far exceed the cost. This is also a good example of how costly it would be to work a case like that. Putting aside the value of your hourly time, what do you think, short of trial, what do you think a case like that will cost the law firm of Summers and Schwartz up to, but before trial?
Just the cost?
Just the cost. Put a number.
So
that we can point to our listeners of how very costly medical malpractice cases are.
So I'm gonna separate the two cases, mom's case and baby's case, because mom's case will require a few experts. I believe costs up until and before trial could be about $50,000 to $60,000. Okay, mom's case.
What about child?
Baby's case, because you're dealing with, again, lifelong neurological injuries and all that stuff, so you'll need psychologists and psychiatrists. It can range between $100,000 to $150,000 in cost.
$150,000 cost. So there is the point we're making to our listeners. The kind of cost in this case, without going to trial, is somewhere between for mom and child is somewhere between $150,000 to $200,000. Now, if you go to trial,
honestly, I don't want to say double, but take that number and add 75% to whatever that number is, close to it.
Right, that's another 150, because you have to bring all these experts, ideally live. Right, a lot of experts who have to testify at trial. So there, we just made the point of how you have to turn down cases sometimes, because even if there was negligence, if the damages are not so high that they justify the cost and your time, that's another thing. We didn't even factor your time as a lawyer with 35 years of experience. So that's a good example of a case where the injuries are permanent, at least as to mom. We will see as to child. We pray not, but only time will tell. And for the child, the injuries will be lifelong. And, in future medical education, in medical cost, and in education, this child may need specialized education that's very, very costly, cannot go through the regular school system, and so forth and so on. So that's a good example of a case that cost is so high. If the injuries aren't way higher, you are on a treadmill that's in essence going nowhere.
Right. So mom's case, just so you know, she's got permanent damages, and she's never going to have children. She's going to have to be on medications for her life. Under Michigan law, again, we have caps for medical malpractice. She falls under the higher cap. Okay. Baby.
Because of the loss of reproductive organs.
I'm sorry, because she, that's correct. One of the exceptions to the high cap is that you have to show that you no longer have the ability to have children or procreate. And she's not going to be able to do that. And for the baby, I'm sorry.
There is no, is what I'm saying. There is no limit.
For the baby?
For her?
Well, she'll be capped. The cap currently, just so you know, for higher cap.
Yes. Is that 600?
No, it's up to, I hope I don't get this wrong. I think it's up to about almost 788,000 now.
Okay.
And the baby, I'm sorry.
Yes, and the baby?
The baby's injuries are in the millions, because the baby, like you said, is going to require round-the-clock care. If, in fact, he's got a significant brain injury, might be wheelchair-bound, might need braces, special education. It could be in the millions. That's all I can say.
Yeah, so that was a fabulous, fabulous, fabulous show. We thank you so much for your expertise. The show will be on YouTube within the next 24 hours at the Joumana Kayrouz YouTube. Have a wonderful rest, beautiful of the sunny day. And God willing, we'll talk to you next month. Rami, thank you very much. شكرا لكل المستمعين.